phone. It's 5:30. I'll call this meeting of the Blowing Rock Board of Adjustment to order. My name is E.B. Springs. Down here is Paul McGill, Mr. Stephen Schiller. This is Ms. Sarah Murphy and Mr. Brandon Walker, and we are the members of the board tonight. Before we get into the variance hearing we're going to do this evening, we got a few housekeeping matters to do. And the first one is the minutes from our January 29th meeting. Did all the board members get a copy of those minutes?
Yeah.
Paul, you got them?
I've got them. Yeah.
Okay, all right.
I printed out 19 pages.
Okay. Did any board member spot any errors or glaring omissions or things that the board member feels like should have been put in there but weren't included? Anybody have anything? Okay, I've got a few things. The first one is on page 9, and right in the middle of that page, it says Planning Director Kevin Rothrock presented the staff report, and then it goes into what the staff report said. If you would, Ms. Miller, have it say Planning Director Kevin Rothrock presented the staff report, Mr. Rothrock said, or then he read the staff report. Either way, just so we know what's coming next is the staff. That's on page 9. On page 10, up on the second line over towards the right, it says any non-conforming one use that has been, that number 1 is a typo. We don't need that number 1 in there. You see, you're up at the second line at the very top over on the right. This is page 10. It says any non-conforming one use. So that little 1 has no, shouldn't be. Turning to page 12. The third paragraph that concludes, Mr. Johnson said no. Underneath, if you would please, Mr. Chad Hollister then stated his case, colon. So just add Mr. Chad Hollister stated his case, or then stated his case. Down at the bottom of that large paragraph, same page, page 12, it concludes, recognize the property's lawful non-conforming use. And then he said, thank you. And if you would include his thank you there, this is Mr. Hollister. So just put thank you after the lawful non-conforming use. Come down, if you would please, to the third paragraph from the bottom. And it says, Chairman Springs asked Mr. Hollister if any of these units were short-term rented prior to August 13th. If you would, add a little bit more of what I asked him. Have it read, Chairman Springs asked Mr. Hollister if he knew of his own knowledge if any of these units were short-term rented. So if you would please add if he knew of his own knowledge. The last is the last page with the signature lines. And it's got the clerk on the right and the chairman on the left. If you would just reverse those. You see the signature lines? I make a motion that we accept the minutes of the January 29th, 2026 meeting with those changes. Is there a second? A second. Mr. Schiller seconds. Any further discussion? All right. All those in favor of accepting the minutes with the changes just articulated by myself, say aye.
Aye.
Aye. It's unanimous, and so that takes care of those minutes. Now we're going to turn to a variance application. It's variance number 2025-03. The applicants are Michael and Allison Jerzenbeck. And before we really get into it, I want to ask my fellow board members if they have been by this property. We are allowed to drive or walk by the property in question and look at it. I looked at it this morning at about 10 o'clock.
I did
Mr.
not have a
McGill
chance.
Has not. Mr. Schiller has. Ms. Murphy has. And Mr. Walker has. When I went by the property this morning about 10 o'clock, the zoning hearing notice sign was on the ground. Can you pull that up for us? And there's the sign on the ground. I know it sounds like I'm being picky, but both the state of North Carolina and the Blowing Rock ordinances say that the sign let me see if I can find the wording. The sign should be prominently posted prior to the hearing. Obviously, that's not as prominent as the state legislation of the Blowing Rock Town Council intended. Fortunately, notice of these hearings, there's a lot of overkill built into it. All the adjoining property owners are sent a U.S. mail letter telling them about this. And the town of Blowing Rock goes over and beyond and takes out a newspaper ad, which I assume he did in this case, Mr. Johnson, is that right?
That's correct.
And publicly posted notice of this hearing. I've talked to our town attorney, Mr. Petrick, about this and told him that given the other forms of notice to the public and the fact that this is a dead-end street, which kind of reduces the interest to the public, that I feel like the sign, even though it's on the ground, it is exposed with, and it's quite readable, as you can see there, with the Z for zoning. I feel like it's enough that we can proceed with this hearing. The alternative would be to not have the hearing tonight and postpone it to another time, which I don't think is necessary. I'm going to ask the two parties, the town and the Jerzenbacks, if they object to proceeding with this hearing tonight. Mr. Petrick?
So I went ahead and looked into everything, and I looked at the town code, I looked at state statutes and relevant case law. I didn't see anything in either of those that would merit or warrant a continuance of this matter. So I don't have any objection with us proceeding with this. Unless there's any, I would say, unless there's any new evidence that would suggest that this sign was not properly displayed for at least 10 days prior, but so far, based off the information, before the board, I don't think that there's anything that would suggest otherwise. So I do not have any objection to continuing the matter today.
Okay. Mr. and Mrs. Jerzenbeck, do you object to having this hearing tonight because the sign was crooked laying on the ground?
And I'd like to add, I was unaware the sign was down. We live in Charlotte, and we hadn't been here the last 10 or 12 days.
No, I was here last Monday, it was up.
Yeah, it was up.
I left last
She comes up more than I do.
Yeah.
Well, let's
And I just realized it was down today before I got here.
okay.
And
Let's do this. Let's go ahead and
the winds maybe blew it over.
let's swear everybody and put this really into the record. Because in my experience, it's the little silly things that bite you later. So I'd like to really address this fully. So Mr. Johnson, the Jerzenbacks, if you would.
I'm guessing this is a snowplow incident.
Oh, I
mean,
think so too.
yeah.
We don't know. We don't know.
No, I'll speak.
Do you solemnly swear that the evidence you shall give to this body in this matter being heard shall be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Johnson, do you remember, did you put the sign up?
Yes, I did.
Do you remember when you put it up?
On Friday, February the 13th.
Okay, all right. Did you install it correctly, straight up? and in?
Thought it did. I'm sure the ground was froze, but it was up.
Okay, all right. And Mr. Drizzleback, you said one of you said you noticed, you did.
Yes, I left last Monday afternoon, and the sign was up.
Mr. Chairman, I saw it on Friday.
This past Friday?
My guess is it's snow removal. I
Right.
saw it Friday before the snow on Monday, so that would have been, not sure what day.
23rd.
He built a deck in the back, so I was there. I did notice the sign up.
Okay,
That was Friday before the storm on Monday. So,
That would have been the 16th.
I know it was there that day. My guess is the snow removal knocked it over Monday. That's just a guess, but I can't confirm it was there Friday. Yeah, that would have been the 20th.
Friday, February.
okay, so we know it was there a substantial period of time, we just don't know exactly how much? Okay. Does any board member object to us proceeding with the hearing with the crooked sign?
No.
I call it the crooked sign because it is there, it's just not straight up and down.
Welcome to Bull Rock.
Okay. I have to ask if any board member has any kind of conflict of interest. And let me go through the list here. First of all, does any board member have any ex parte prior to the hearing communications about this case? Anyone have to disclose any ex parte communications? Hearing none from any member. A member must not have a fixed opinion prior to this hearing on whether this particular variance should or should not be granted, should not be biased. Does anyone have a fixed opinion prior to the hearing? No. I'll say no. A member must not have a fixed opinion as to whether all variances in general should or should not be granted, should not be biased. Anybody feel like no variance should ever be granted? No, it's all no. And a member should not participate in this case if the member has any close family, business, or other close relationship with the person involved in this case. Anybody have any close associations involved in this case? No? No. And it's all no by every member. And a member must not have any financial interest in the outcome of this case. No for myself. Anyone have a financial interest in the outcome of this case?
No.
Is there anyone other than the town of Blowing Rock and the variance applicants who considers himself or herself to be a party to this case? I hear nothing. Is there anyone that feels like they want to be a witness in this case? You're not a party, but you are a member of the public and you want to be a witness. Is there anyone here like that? I hear nothing. Mr. and Mrs. Jersenbeck, the person keeping the minutes of this case are Miss Taylor Miller, and she works for the town of Blowing Rock. She works for the Planning and Zoning Office. I'm telling you this because even though these variance hearings are always very congenial, the town, if it wanted to, could oppose your variance, meaning your opponent is keeping the minutes. in general, the town doesn't oppose them. They state the facts very simply and dryly and step back. But do you have any objection to Ms. Miller keeping the minutes? No objection. The North Carolina Court of Appeals has said that we should tell the parties the procedures we're going to follow, and so I'm going to tell you that now. This hearing is a quasi-judicial hearing. It is conducted according to the rules and laws pertaining to quasi-judicial hearings. It will have all of the essential elements of a fair trial. Parties will have the opportunity to give evidence, cross-examine witnesses, inspect documents, and testimony shall be under oath. The board's findings will be based upon substantial, material, and competent evidence. The North Carolina Court of Appeals has said repeatedly that the decision of a board such as this must be based upon substantial, competent, and material evidence. In North Carolina General Statute 160D-406, paragraph J says the same. Substantial evidence is defined by the Court of Appeals as that which a reasonable mind would regard as sufficiently supporting a specific result. The court has also said that it's such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Material evidence has been said to be evidence having some logical connection with the consequential facts. And competent evidence is generally defined as synonymous with admissible evidence. It follows the rules. We're supposed to follow North Carolina rules of evidence, the rules used in the North Carolina General Court of Justice. The type of evidence question that most often comes up is hearsay evidence. Hearsay is a verbal or written statement made prior to the hearing and the declarant is not here or on the telephone to testify under oath. The rules say hearsay is not admissible unless allowed under a statute or by the rules. And the rules have a number of exceptions that will allow the hearsay to be admitted into evidence. Probably the most used exception to the rule against hearsay is the exception for statements that were made outside the hearing by a party opponent. The party opponents here today are the applicant and the town. They are opponents. What they or their agents or employees have said outside the hearing is admissible as a statement by a party opponent. It's a hearsay exception. If the appellant testifies that the planning director or his assistant a month ago said such and such about this case, that statement would be admissible as an exception to the rule against hearsay. And if the planning director testifies that the appellant or the appellant's employee or agent said such and such about this case, that would be admissible. We, the board, cannot make critical findings of fact based on hearsay. If we hear what sounds like inadmissible hearsay being offered into evidence, we shall stop and discuss that situation with the parties. Let me speak to you a minute about unnecessary hardship. Before we start the variance hearing, let me talk about the first requirement for a variance, the unnecessary hardship the applicant must show. Unnecessary hardship is not defined in the state statute nor in the Blowing Rock Town ordinance, but they require the applicant to show he or she is suffering unnecessary hardship. The North Carolina Court of Appeals and Supreme Court have also not defined it or explained it. So where do we turn to have a working definition or explanation of what unnecessary hardship is? We, this board, turn to the authority, who trains the North Carolina legislature in municipal and land use law, that being the UNC School of Government's professors. The most respected and the most active in the field are the fellows who wrote this book, the handbook, the quasi-judicial handbook, a guide for boards making land use decisions. David Owens and Adam Lovelady authored that book. They are professors at the UNC School of Government. David Owens also wrote with Professor Adam Brueggemann the textbook, A Survey of Experience with Zoning or Variances. A lawyer preparing a court case who needs to establish a definition for something looks first to the statute. If it's not defined there, he looks to the judge, made law from the Court of Appeals of the State Supreme Court. If it's not defined there, he looks to learned authorities, such as these professors who teach public officials, such as the legislator. The UNC School of Government would say that all zoning is a hardship. It limits property owners' rights to do anything they please with their property. But zoning's allowed as a public good. All the states provide for some legal bending of the zoning laws by way of variances. There are properties which could not be used for anything if all the zoning laws were rigidly applied. That would be considered a taking by the government. In North Carolina, a variance applicant has to show a number of things, and the first that he suffers from unnecessary hardship if the zoning rules were rigidly applied to his property. The school of government would say it is fair for all of the property owners in a neighborhood to suffer the same degree of hardship due to the zoning rules. But they would say it's unfair and excessive for the zoning rules to impact a property more than the other properties in the neighborhood due to the unique characteristics of the property. That's excessive. The adjective unnecessary is a poor choice. Think of it as excessive or unfair hardship. The applicant for a variance has got to show the problems with his lot. Those problems are worse than what most property owners in the neighborhood have to contend with. Now, the zoning, the Planning and Inspections Office has sent out what's called the staff report. I'm holding the copy I received. Have all the board members received the staff report for this case?
Yes.
They have. Mr. and Mrs. Jersenbeck, did you receive a copy of the staff report?
Yes.
Okay. And it was prepared by the town. Mr. and Mrs. Jersenbeck, do you have any objection to any part of the staff report that you received?
No.
And generally, we're going to hear from the town, and we want to hear from you, Mr. and Mrs. Jersenbeck. You did prepare a very nice typed summation of your position, but we would like you to get up and speak to us.
Sure.
But we usually start with the town. If you'd rather go first, you may, but generally we start with the town. Do you have a problem with that?
Start with town.
Okay, very good. Mr. Johnson, are you going to present the town's case?
Yes, sir.
Thank you. If you would, proceed.
Thank you, Chair of the Board. I'll present and give a background and a request from Mr. and Mrs. Jersenbeck. This is variance case 2025. In your packet, there is a survey, and a large survey that maybe help you see a little bit better, and also include a copy on your desk that might help to see a little bit better as well. There's also, including the letter, there's also some photos that we can reference as we go through, and be glad to circle any of those when we get there. Michael and Allison Jersenbeck are requesting a setback variance from Land Use Ordinance Section 16-12.4. It's the R15 zoning R15 street setback, and Section 16-12.4, the R15 side setback. The intent for the request is to construct my understanding is a garage or a small storage building, golf cart garage. Property is located at 243 Clawson Drive and is further identified by Watauga County PN 2817-18-7347-000. And again, the property is zoned R15 single family. The first request, there's actually two requests as part of this. The first request is a 26-foot setback variance from the applicable 30-foot street setback, which is required along Clawson Drive. The second request is a 7.7-foot setback variance from the side setback. Short direction of video, it's the required 12-foot setback on the side. Again, the request is for a 16-foot, I think in length by 12-foot width golf cart / storage shed. Just for reference, The existing house is within the front street setback, and a portion of the rear deck was also within the side setback. As you can see here, this is a 30-foot setback here, applicable along Clausen Drive, front of the house here. And it's not relevant, but there's a few encroachments here. This is a 12-foot setback that would extend here and obviously further extend there. This is the location, 12 by 16 garage, property line, and this dashed line I think is referencing the actual street edge, pavement edge. We can get some site reference to the this is the proposed elevation, and Michael can let you know if this is still accurate or if this is similar to what he's wanting to propose. And my understanding with him also is the intent is to match the elevations and materials of the house itself. I think in relation to this picture, where you would be looking at, and my understanding, Mike can verify this, but I think the intent is to remove the existing wood shed that's there, which you can see in some of those pictures. I'm not sure about his trash here, I'll let him speak to that. But this is the vicinity and the location that the proposed building is going. Going back to the survey, the larger one here. This is a retaining wall here, and the house sits a little bit below that, and then the slopes obviously on this upper side there. That's all I've got. Any questions, any clarifications? Be glad to help out.
Does any board member have any questions of Mr. Johnson? I've got a few, Mr. Johnson. Mr. and Mrs. Jersenbeck, do you have any questions of Mr. Johnson?
No.
The aerial photographs, were those supplied by the Jersenbecks?
The first one, taken away, I provided that
Okay.
photo, and the rest were provided by the Jersenbecks.
So they provided some photos and you provided some photos?
That's correct.
How about the plat? Who provided that?
That was supplied by the Jersenbecks, but
Okay.
I obviously included in the packet.
Okay. Let's go back to the notice. Was proper notice of this case and hearing given to all the property owners with property abutting the Jersenbecks house?
There were 9 notices sent to 9 property owners within the 150-foot requirement,
Okay.
10 including the Jersenbecks themselves.
Okay. And did you hear back from any of those 9 property owners?
Did not hear back from any of the folks that received notice.
Okay, don't tell us what anyone said or whether they're pro or con, but did you receive contact from members of the public about this variance?
I did,
How many people?
just one. It was an adjacent neighbor in the neighborhood. That neighbor had actually, I guess for the record, had called on February the 17th
Okay, is that person here? And again, the 9 neighbors that you mailed notices to, you heard back from none of those 9 contacted you?
No, sir.
Mr. Johnson, you said you put up the zoning sign. You've obviously been to the property and been up and down Clawson Drive. Looking at what you understand to be the Jersenbeck's proposal, what they want to do, would what they're proposing impair emergency vehicles such as fire trucks and ambulances?
I think the only thing on my mind would be, I don't think it would impair any access, but we do have a section in the ordinance that it's related to our fence section. We typically require structure fence, those types of things, minus the setback to be at least like 6 feet off of a street edge. And the only thing in my mind is if you look at this distance here, that's the edge of the corner of the proposed building, and that's 4 feet to the property line. But with this being the street edge, probably 6 or 7 feet there. That would be my only concern was, I don't think it's going to impair any access. But obviously it's pretty close there to the street edge.
Is that 6 feet a guideline or a local?
It's a town of
tradition?
Blowing Rock guideline, and typically the main purpose is for any obstructions, site visibility, snow plowing, snow pushing. Obviously, snow pushing does knock things down. It's just to give a little bit of relief off the street edge. I don't think it would impair any access to the house itself.
Okay. The 6 foot street edge, the edge relief, is that something that our local fire department has discussed with your office, to your knowledge?
Not to my knowledge. I mean, I don't think it's a fire issue. I think it's just more of a zoning code that's been in. Whether there's any discussion with the fire department, I don't know, but I don't suspect it was.
Okay. What the applicants are proposing, would it create a fire hazard?
No, sir.
And what the applicant is proposing, would it block or impede visibility on any street or highway?
I don't suspect it would there, but just going back to that, 6 or 8 feet would, maybe be a thought there. The property, the adjacent property to them, this property here is undeveloped at this time. And obviously the road curves this way, but I don't think there would be any site visibility issues, but obviously the more separation you can keep off of that street edge is, I think, worth looking at.
Brent, what section of the code is that in, if you know? Is there something I can search for? I have it pulled up.
I got it over here, just give me just a minute. Sorry, it's stuck in here. Section 16-11, .2.2. No fence or wall shall be constructed within or upon any street right of way or easement. In addition, no fence or wall shall be constructed within 6 feet of the edge of any street pavement. Like I said, I don't anticipate it being a access or safety issue. Site visibility for an adjacent neighbor or consistency with this section, I think is worth looking at. And Michael, he might be able to speak to if there's any adjustment to accommodate that. It's kind of stuck in at the end of the permissible use table there. 11-1.
Hidden.
Yeah,
Should be the first few paragraphs there under fences.
Are we in 6 feet?
Yeah, they're 4 feet.
where is that again? I can't find it.
16-11.2. Listen,
I'll just.
how you
All right.
the Blown Rock Code does say 6 feet. The Board of Adjustment, though, can, in its decision, override any of that land use code, so we'll see. Any more questions from the board or Mr. Johnson? Mr. Johnson, one more question. What the applicant is proposing, would it be contrary to public health and or safety in any way?
No, I don't think so.
All right, thank you, sir. You can sit down. Mr. Jersenbeck, are you gonna speak to us? Sure. All right.
Thank you for having us and holding this hearing for us. My wife Allison, I'm Mike. We've been residents of Blown Rock for 11 years. And we've been coming up here since our kids were born. They're all in their mid-20s. We have 3 boys. And we stumbled upon our place back in 15 as a foreclosure, fixer-upper. We bought it and We've enjoyed living here part-time, and we've just enjoyed everything that Lone Rock has to offer. And as we get older, we can certainly see ourselves spending more time as we get close to retirement, maybe living here most of the year. And, you know, just the main issue with the house is storage, you know. We needed a place to put things that we enjoy doing up here, kayaking and golfing and all the things along with that. And the way our lot is, it's angled and it's very steep after you get to the front of the house. And there's really no place to put anything, so I knew I had a little bit of land on our lot, on that right corner. And that's when I looked into building a small garage that, you know, can store a lot of the stuff that we use up here to enjoy the area. So that's when I got in touch with Brian in the town and looked into the process of seeing what we can do to do this. And it's been a learning experience, of course, but we respectfully submit, you know, and request this variance, you know, for the reasons of, you know, a topography hardship. There's nowhere else to put it. We've had the surveyor come out and look at a few different ways to put it in that spot, and they felt like with everything that Brian has told us and what we knew, that would be the best spot to put it. And so we're gonna make it, you know, if we're allowed to do it, we're certainly gonna make it look aesthetically pleasing and match the house. So look very, have great curb appeal, and have a stone foundation. It's gonna look great. It's gonna look like the house. And it's just, you know, there's nothing else we can do and no other place we can put it. And there's really no doing but just the way the lot is, you know? And if you see, it's gonna come, that one corner that will be 6 or 7 feet from the road, it would be that corner, but then it will angle, as you can see, it will angle back pretty sharply away from the road. So you'll have that one little front corner that will be close, but then it'll start angling back pretty quickly. And we felt that was the best way to do it. Yeah, it's pretty steep. Even the back corner of that garage, the back left corner, will probably be, you know, 7, 8, 9 feet to get a foundation or pier to get that back corner. So it's something we've been talking about for quite some time. It would certainly meet a need we have, because we have, you know, we can see ourselves staying up here. We have grandchildren coming up here, enjoying the area, and just, you know, of course, we're not getting any younger, so let's just make things easier to really have some storage in that house, because we want to have. So that's where the idea and came from, and that's what we'd love to be able to do. It is pretty consistent with, I know when the houses were built in that neighborhood, I believe it's Echo Park we are, I'm not sure. I believe we're Echo Park. There's quite a few houses on our side of Sunset and across that were built pretty close to the road, as well as some new structures because of the same reasons of just topography and really nowhere else to put it because of the grade and the steepness of the lot. And I don't know, I feel like it would be pretty consistent with what else has gone on in the area and in the neighborhood. And that's about it. I mean, it's kind of what we would like to do. And I don't know if you have any other questions of how it's going to look or how it will be built. But we're certainly open to do whatever we need to do to make it happen if we need to make some adjustments. We've studied it pretty hard and with the survey and with Brian and going back and forth of making it, putting it in the right spot and making it work. So we feel like it's, you know, it's in the spot where it would need to be. Any closer to the house, away from the road, it gets real steep, and I got propane tanks there next to the house on the other side of that retaining wall. And there's really no, and all my drainage from my driveway goes down, so I do need to leave a little space. Also gonna have a real drainage issue going down, so just leaving a few feet off that retaining wall as well.
Does the town have any questions of Mr. Jersenbeck?
I do not.
Any board member have any questions of Mr. Jersenbeck?
No.
I've got a few. Could you put the plat up again? Any way to get it kind of bigger than, that's the one I want. Okay. And there, we all see the 12 by 16 foot garage. Mr. Jersenbeck, why can't you cock that whole rectangle, the bottom over towards your house, and make more room between the corner of the garage and the road? Why can't
You
you?
mean take it and go this way?
No, the other way.
This way?
Yeah,
So I originally had it perpendicular to the house.
yes,
That's the way I thought it would be.
yes.
When the surveyor came, they said I would actually be over the line, over the property line by like a foot,
Which property line?
the side property line. Yeah,
Is that the only reason he said why he could not build it, the whole thing cocked over to the left?
yeah, so.
Do you know what I'm?
You mean this face would be perpendicular, would be parallel with this, correct? Is that what you mean?
Yes,
Yeah.
yes.
And that's the way I originally thought we could do it.
And the only concern is the side setback?
Yeah, so the side setback, if we did that, I think would be just as close, the same distance from the road. But now the whole structure of the building would be close to the road as well.
Oh,
Versus just this corner.
You're talking about pivoting on this corner,
Yeah,
pivot there and swing that back?
Yeah.
so that the bottom left corner comes over towards the house?
yeah, so you're talking about doing this.
Correct, correct.
Yes, and that's what I'm talking about, the same thing. So when we did that, the surveyor did say I'm over the property line in the back, on the side setback, on the side property line, on up. But also, we would be the same distance from the road, but the whole structure of the building would be along the same distance of the road. Versus, so this building is gonna be probably, you know, in the back, half of that back building is gonna be pretty far from the road compared to the front. Where if we did what you're saying, what I thought would be the best way in the beginning, before the surveyor came out, the whole building would be along the road.
What if you take the upper right and imagine you put a pin there and then just swing it
Exactly,
over to the left?
exactly.
So turn it and bring the whole
So the
thing
bottom
closer.
right is swinging away from the road. The lower left is swinging towards the house, but you'd need to leave enough room for that
Yeah,
range.
it's pretty steep. I mean, if you were to stand here,
Yeah,
it goes down dramatically.
I saw
Right
that.
there. Yeah, so, and right here is only, that's a few feet, and that's where all my water drains and goes down the mountain, goes down the hill.
Right.
And that's a retaining wall, and that's my propane tank, so right there. So, yeah, so that's the corner you're talking about. And about it, real quickly, So, the back of that back left corner of the building will be in here somewhere, okay? The picture don't show it, this gets very steep, and then we're also getting very close to this retaining wall. And the front edge of that building is here, somewhere right around here, and it goes to there. So it gets very steep, but we just felt like having one corner close to the road versus the whole building along the road would be better.
Michael, does that stake there reference any?
That represents the front of that building. And then it goes, you know, it angles out that way.
And that's pretty steep, that's about 8 or 9 feet probably. And you get into like another 8 feet there to go. And then you're getting close to this retaining wall where I need this space for drainage.
So that's where the drainage is going.
Yes,
Right there.
everything from all the way to the other side of the house comes down. It's great because when it snows, I just push my snow right
And from the road.
And
you're
the
getting some
leaves,
runoff.
yep, and all the leaves go right down, so, but yeah, I need that for drainage, and, so the front of the building would be right around here and the back. So,
Could you go back to the plat? Let me kind of cut to the chase, Mr. Jersenbach. I live in your neighborhood. I'm on Mockingbird Lane, just above you. I could throw a rock and hit your house. All along Mockingbird Lane, the lots are pretty flat. And no one has to deal with the steep slope problems you do. You have a steep slope problem, and you're one of the worst on your street. As far as getting some kind of variance, you probably could, if it was the right kind of variance. This ain't gonna fly. This is too close to the street. I can see a house on fire and fire trucks and emergency vehicles getting clogged up there, and it would be horrible. And yes, it's gonna cost you more money to get away from that front street. But what you're doing is just, it's too much. If this house had been built in the 20s and this thing was right on the highway, well, so be it. But in 2026, to let you build right on the street like that, 4 feet from the street, people are gonna think we're crazy, and we would be crazy. It's just not, it's not good.
Is it just 4 feet? I thought it was 6 or 7 feet.
Well, you see the dotted line, the dash and the dots, that's the actual paved road.
that's the paved. That's
And so it's 4 feet,
Yeah, so you're probably 6 feet.
right, 6 feet from the pavement.
It's still too close.
It's got it.
It's just too close.
Could we move it back a little bit?
Yes, it's gonna be more expensive. Yes, it's gonna be a little more difficult. I can't see why you can't just pivot the whole thing, the bottom
When you
left.
say pivot the whole thing, you mean to go back like that?
No.
You mean move, that's my retaining wall. I need to move-
Come down to the bottom left side of the garage, bottom left corner.
Right here,
Okay, go to the left.
this way,
Just move the whole rectangle over to the left.
right here.
Right. That brings it away from the street, the front street. Yes, your top left corner is going to get closer to the neighbor's property line.
Right.
But at this point, it's an undeveloped lot. And we're not going to have the safety issues and emergency vehicle issues that we're going to have with the front street. So
Right.
I can see this board working with you on getting closer to the side setback.
And I didn't know how that worked. I didn't know if I would be allowed to do that or not. This is me
Well-
putting it where I thought it would work, you know?
Well, you're asking to bend the rules and bend them a lot, because you're asking for a 26-foot gift in the front, actually. You're asking a lot. I think you can get over the unnecessary hardship, because you are one of the steepest and most difficult lots in the neighborhood, and building a garage, even though it's just for storage, it's not for real cars, all right?
Right.
That's not unreasonable, but you're too close to the street. It just looks scary.
Mr. Chairman, is there a question of a reduction in size of the building? I mean, that's a question for him, obviously.
If I moved it and made it smaller, could we make that work?
Well, you'd end up with, you're gonna have to make it a lot smaller. It's gonna look weird. fellow board members,
So you're talking, you wanted him to do this, and this is what he's saying, is the whole thing. If you pivot this way, the whole thing, now the whole thing is closer to the street.
oh, I see what you're saying, yeah.
That's what.
And then the other thing,
6 foot.
you gotta remember this
Six
house.
foot.
They built it right.
That's what-
We
Isn't that what the
two
code
things,
says?
right?
Drive
Yeah,
6.
that's what it's saying.
Do you remember this?
So I don't see a problem with it. I think
Was
it's
it
gonna
this
be worse
close?
if he starts cutting around and having more toward the front.
It was,
I do remember that.
yeah, so, we gotta think about that too. Now, this is my little drawing into scale, but that's in essence what he's saying.
Could you, the proposed garage is a rectangle, a 12 by 16 rectangle. Could you leave the basic structure where it is and come from the top right corner 2 feet over from the left, so it's no longer a perfect rectangle, it's a little bit odd, yes, just like that.
So make it 10 by 16.
And, yeah,
I can do that, yeah. I would be fine with that. If that's. if you
Get
give
them
2
6
more
feet off
away
the
from
street.
road.
I have a
Or
question for
even notch
Brian.
the front of it, just notch a piece out. I mean, just
I've,
have it notch a piece out there at the front, 2 feet out the front, don't go 2 feet all the way back.
Yeah, like take a little
I mean,
triangle.
if you are okay with me going back 2 feet here, since it's a side variance and there's no lot here, that's gonna bring me to here.
But he's only got 6 feet from the road, and that's what it said.
If I moved it back to here and made it 11 or 12 wide, it's gonna fall. Now we're probably 8 or 9 from the road, 9.
6.
But I can make it less than 12. It sounds like the depth, the length ain't an issue.
Mr. Johnson, right now, what's the distance between the back of the garage and the sideline?
4.3.
Okay.
And Joey might can correct me if I'm wrong here, but I think as proposed, you would need to grant both the side variance and the front street setback variance as proposed there. So, okay. Yeah, it's 4.3 from the side there that you see.
Brian, I see that it's 4 feet from the property line at that lower right corner, correct?
Yes.
How do you know exactly how far it is from the actual edge of the street, the asphalt?
This here?
Uh-huh. That's
So-
4 feet from the property line, right?
So you've got 4 here, right? That line, that line. So I think a guess right here is about 2 to 3 feet probably.
So it's 6 to 7
So
feet
it's about
from the
6 to
asphalt.
7 feet. I would suspect 7 feet.
Okay.
Obviously it goes and loses here. And gets further away. And it's common, we have lots of trash bins around town. I mean, that's just the nature of the way things have worked. I don't know if Michael has any intent of removing this or not.
Yeah, I would remove that.
But it does run away, obviously, as you go that way. But my best guess would be 7 feet or so.
You think that's enough?
I think that's enough.
I do too.
That satisfies 1611.22.
Yeah.
Okay, well, I feel better now that we've added 2 feet of clearance.
And it's from the edge of street pavement, not the property line, so.
That's correct. I feel like it's good. He done what he needed to. Giving the variance.
All right, are we back to
I think it's okay the way it is.
comfortable the way it is?
I think it's.
I'm comfortable that 1611 is not an issue.
Okay.
Maybe back to the question, let me go to his elevation real quick. Where'd it go? is this 16 feet, excuse me, 12 feet, 12 feet, 12 feet, or is it 12 feet here? See what I'm saying?
Yeah, well, the foundation's 12 feet, so.
So again,
I would
that's
make that
probably a question.
Easement, make that eve as small as possible.
So eaves are included, that's a part of the structure in the setback that has to meet it.
I could,
Gutters do not, but just the eaves.
and I can build around it, I can just,
I think you'd want an eve, that's just
Yeah.
me, but, I'm just food for thought. I know we had this come up on a previous one.
All right, let me ask you just one or two more questions and we'll wrap up. Do you know when the house was built?
1982, I believe.
82?
Yes, sir.
I'm gonna write around 1982. All right. Thank you, Mr. Jersenbeck. You can sit down.
Thank you.
All right, findings of fact. If I misspeak or leave something out, as always, let me know. Here we go with findings of fact. The applicant is Michael and Allison Jersenbeck. The owner of the property in question is Michael and Allison Jersenbeck. I didn't ask you, but are you on the deed? Are you the owners?
Yes, sir.
Okay. The address of the property in question is 243 Clawson Drive, Blowing Rock, North Carolina. It was built around 1982. The PIN number is 2817-18-7347-000. The property is zone R15. The applicant wants to do the following, which would violate zoning regulations and which would require a variance. Wants to build a garage, which would intrude 26 feet into the 30-foot required street setback and would intrude 7.7 feet into the required side setback of 12 feet. The Blowing Rock zoning court ordinance section, which is at issue here and which stands in the applicant's way, is 16-12.4. And put into words, the ordinance requires a 30-foot setback from the street right-of-way line with no construction to take place within that 30 feet, and requires a 12-foot side setback from the lot boundary line with no construction to take place within that 12 feet. There are not other parties withstanding to come into this case. The applicant did provide drawings or sketches or plans or pictures illustrating what the applicant wants to do. The Town of Blowing Rock has provided and given all necessary legal notices of this case in this hearing. There was proper notice of this case and hearing given to all property owners with property abutting the parcel of land which is at issue here. The applicant did receive a copy of the planning director's staff report prior to the hearing. There were not other witnesses in the hearing besides the applicant and the planning director. Excuse me, that's the zoning enforcement officer. And relevant evidence, excuse me. The only witnesses were the applicant and the zoning enforcement officer. What the applicant is proposing would not impair emergency vehicles such as fire trucks and ambulances. What the applicant is proposing would not create a fire hazard. What the applicant is proposing would not block or impede visibility on any street or highway. What the applicant is proposing would not be contrary to public health or safety. Unique features of this property include a very steep slope, which makes construction any place other than the proposed location for the garage. Virtually impossible. First of all, let me do a motion to close the evidentiary hearing. Do I have a second on that? Second by Mr. Schiller. Any further discussion on closing the evidentiary hearing? Okay, I propose, or I make a motion that we accept the facts as I just articulated them. Is there a second?
Second.
And Mr. McGill seconds. Any further discussion? All in favor of accepting the factual findings as I articulated them just now, say aye.
Aye.
Aye, it's unanimous. Moving to the conclusions of law. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case unnecessary hardship would result from the strict application of the regulations. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. The topography of the property with a steep slope is more challenging and worse than the majority of the neighborhood properties. I move that we find that the Jersenbecks have met their burden of proof on the first factor.
Second.
And is there a second?
Second.
Mr. Walker seconds. Any further discussion on the first factor? All in favor of finding that the Jersenbecks have met their burden on the first factor, the unnecessary hardship, say aye. Aye. Aye, it's unanimous. The second factor, based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. I move that we find that they have met their burden to show that in this case the hardship results from conditions peculiar to the property. Is there a second?
Second.
Second by Ms. Murphy. Any further discussion? All in favor of finding that the applicant has met their burden of proof for the second factor and that the hardship results from conditions peculiar to the property, say aye. Aye. It's unanimous. Turning to the third factor. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material competent evidence exists to conclude that in this case the hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. I move that we find that the Jersenbecks have met their burden to show that the hardship in this case did not result from taken by them. Is there a second for that motion?
Second.
Second by Mr. Schiller. Any further discussion on that one? No further discussion. All in favor of finding that the Jersenbecks have met their burden on this third factor and they've shown that the hardship did not result from actions taken by them, say aye.
Aye.
It's unanimous. Turning to the fourth and last factor. Based upon the evidence presented and the facts shown above, the Board of Adjustment finds substantial material and competent evidence exists to conclude that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. Substantial justice is not achieved when granting the variance would be injurious to the neighborhood or to the general welfare. I move that we find the Jersenbachs have met their burden of evidence to show that in this case, the variance would be consistent with the spirit, purpose, and intent of the regulations, and public safety would be secured and substantial justice achieved. Is there a second for that motion?
Second.
Second by Mr. Schiller. Any further discussion? All in favor of finding that the Jersenbachs have met their burden to prove that in this case, the requested variance is consistent with the spirit, purpose, and intent of the regulations, such that public safety is secured and substantial justice achieved. We did just vote, right?
Yeah, we did.
Aye. No, we didn't vote.
We did.
We didn't vote.
Yeah.
All those in favor say aye.
Aye.
Aye. It's unanimous. Okay. Getting old. The Board of Adjustment does grant the applicant a variance to take the action stated in fact number 5 above, with the board making the following changes. There are no changes.
Do we want to notate anything about, that the eaves need to be inside?
Yeah, let's do that.
The 6 feet?
Let's also note that, the applicant may build the proposed structure 26 feet into the front street setback, and may build the structure. How many feet, Mr. Johnson, into the side setback? What was it?
7.7.
7.7.
7.7. 7.7 feet into the side setback. So including the eaves and those columns that look like down at the bottom of the structure.
Can you go back to that picture?
Nothing's going to get any closer than 26 feet into.
Yeah, it looks like the eaves come right above that foundation.
We never made it clear whether the side walls, we're going from the side walls or we're going from the overhang. Which one are we going from?
My understanding, it was the side walls, so I'm assuming the columns are going to be a little bit further out in the eaves. We can verify with Mike and have the surveyor make
It
sure.
might be just like a drip edge of 2 inches of stone, of apron.
Well, we need to be more precise. This is where we have to pin everything down. The eaves of the roof would extend no more than how many inches over the sidewalk?
I think if you set 26 as a max,
From the eaves?
well, I think if you allow the 26 foot in the setback, we can adjust that with the survey, which won't be much.
Okay.
And we can work with him on the width of those. And it may be a foundation adjustment, just a little. I think he's got a little
That's
wiggle
my other
room.
question. Can I ask a question?
Okay.
If I feel like I have the room to move it another foot away from that road,
Okay.
I can do that? Like, how does that work? Like, once we get-
That would be fine.
Yeah.
They're granting you up to 26 feet. And I
Okay.
think, we can make
Okay.
the survey. Does that seem right?
Oh, that'd be great.
Yeah.
Yeah, no, I don't
Move it
mind.
all you want.
And what about the side setback? If I decide to push that back 1 more foot close to get it even more away from the road? Like, I'm just trying to.
No, you can't do any
Any more.
He
do less.
can move it less.
Sure.
Yeah.
Yeah, I can move less, but I can't move the back of the building.
Closer to the
another foot.
property.
That's another hearing.
Okay, it's another, okay.
So I'm
I
gonna,
just didn't know what the wiggle room is.
I think we're on the same page.
I'm gonna write this, no part of the structure will be any closer to the front street. What's that line at the street called? That'd be the front street.
Which line? The
The
street
right-
edge
The right of way or the street edge. The 26 feet goes to the right of way.
goes to the right of way, correct? Not the street edge, but the right of
So
way.
no part of the structure will be any closer to the front street right of way than 26 feet. No part of the structure will be any closer than 7.7 feet to the side setback. So the eaves and the foundation, the whole shebang has to be within.
Basically, just as it's shown in the drawing, so that outside line has to be like eaves, foundation, whatever the closest thing is, that's as far over as it can go. And you could, shrink it, but not expand it.
So let me repeat that. The Board of Adjustment does grant the applicant a variance to take the action stated in fact number 5. Lost my place. And the applicant may build the proposed structure 26 feet into the front street setback and may build the structure 7.7 feet into the side setback. No part of the structure will be any closer to the front street right of way than 26 feet, and no part of the structure will be any closer than 7.7 feet to the side setback. I make a motion that we accept that pronouncement and grant the variance to the jurors and backs as articulated. Is there a second?
Second.
Second by Mr. Schiller. Any further discussion?
I would consider adding, as an additional condition, potentially that no part of the building, because we have an estimate of 7 to 8 feet from the asphalt, so that no part of the building violates 16.11-2.2,
Which is 6 feet.
which is 6
6
feet.
feet.
Because right now we have an estimate. We think it's 7, 8 feet. So I think we should just add that to cover all the bases.
Okay, all right, I'm getting confused.
Well, we're talking
just
about
saying-
where the pavement ends.
Not knowing this known point right there is what I think what Brendan's referring to.
So the dotted line where you are right now, Brian,
Yes.
to the corner of the building, has to be 6 feet or more.
Yes.
Is that correct?
That's all in that.
And he's wanting to put
Must
that in.
comply. I just wanted in here, must
The problem is,
comply.
that's the edge of the asphalt, right, the broken
Yes.
line?
It's right here.
That's so screwy, because some parts are broken up and some parts, the thing we can pin down though is the lot line, which is the bowl line, right, a little further in towards the garage.
Right.
So I just feel like the edge of the asphalt is.
But that's what
kinda
the
weird.
ordinance says. And so John or Brian will be up there making sure that the ordinance is
And
complied
it's
with.
typical for street edges to go in and out, but we can get an average and know where it's at.
Okay, so you would want to say, no part of the structure will be any closer than, what was it, 7?
Or just not violate, no part of the structure will violate 4-11-2.2.
I think you could set a distance.
Yeah, I'd rather just give a good, just a number,
Well, it's 6 feet.
6.
And he can have the surveyor verify that.
That'd be no closer than 6 feet from the edge of the
Current pavement.
current street asphalt.
It's typically it's defined street edge in the
Edge of the
ordinance.
street?
Pavement edge
Street
sometimes.
edge. All right, no part of the structure will be closer than 6 feet to the street edge.
Yeah.
And I feel comfortable from a staff perspective that we can work with him to get it.
Okay,
You know, it may be there now. I think Brandon is just wanting to make sure, since we have the unknown point, but I think we can get it 8 feet off the pavement there. Dealing with the eaves as well.
okay, okay, just so no part of the structure is closer. Okay, all right, so with the changes suggested by Mr. Walker that no part of the structure will be closer than 6 feet to the street edge, I make the motion. Is there a second to grant the variance as stated?
Second.
Second by Mr. Schiller. Any further discussion? All in favor of granting the applicant a variance to take the action stated in fact number 5. And the applicant may build a proposed structure 26 feet into the front street setback and may build the structure 7.7 feet into the side setback. No part of the structure will be any closer to the front street right-of-way than 26 feet, and no part of the structure will be any closer than 7.7 feet to the side setback. No part of the structure will be closer than 6 feet to the street edge. All in favor of adopting that finding? That conclusion of law, say aye.
Aye.
Aye, it's unanimous. This decision is effective after review and approval of the written decision by all participating board members and then filing with the clerk. And I move that we adopt our conclusions of law as just stated, all the factors and the granting of the variance as stated. Is there a second of that motion? Second. Is that Mr. McGill? Any further discussion? All in favor of adopting the conclusions of law as just articulated, say aye.
Aye.
Aye, it's unanimous. All right, Mrs. Jerzelbeck, you got your variance.
Thank you.
I make a motion that we conclude this meeting of the Blowing Rock Board of Adjustment.
Second.
Seconded by Mr. Schiller. All in favor, say aye. Aye. Have a good evening.